we'll first get them out of the picture because there were
But
many
the
states
state
which
of,
had complied.
state of West
Madhya
Bengal has
Pradesh has filed
applied.
an affidavit.
The chief secretary is also present.
Madhya Pradesh has filed an affidavit. So
Yes, I have
they have fully complied and copies given to the amicus.
Yes.
That so
They are
far as,
complied with it.
far as Meghalaya, Himachal, Madhya Pradesh, and TN are concerned, Tamil Nadu are concerned, my lord, those are clear today.
Madhya Pradesh,
Madhya Pradesh, they have
Madhya
complied.
Pradesh, Himachal,
just one.
Meghalaya, and Tamil Nadu.
Tamil Nadu,
West Bengal also I gave it to.
Meghalaya and Himachal.
Meghalaya, Himachal, Madhya Pradesh, Tamil Nadu, my lords. So far as Tamil Nadu is concerned, just one order is required that they have made available those funds. The judicial officer to raise the bills within 4 weeks, and thereafter within 4 weeks the state should comply with it. Otherwise, these 4 states are clear. Your lordships may.
All right.
So West Bengal is also.
First of the order dated 22 August 2024. The chief secretaries and finance secretaries of the states of bracket 1 Tamil Nadu, 2 Madhya Pradesh, 3 Meghalaya, and 4 Himachal Pradesh. Mr. K. Parmeshwar, the amicus curiae, states that of 4 states not be that proceedings against the aforesaid states, the above 4 states, need not be pursued any further. So far, next. Don't say next. Insofar as the state of Tamil Nadu is concerned, it might have been stated that the funds have been made available for disbursement to the judicial officers. To stop. The judicial officers are accordingly. Next line. The judicial officers in the state of Tamil Nadu are accordingly permitted to raise their bills as requested by the in terms of the request made to this court on behalf of the state of Tamil Nadu within a period of 4 weeks. Full stop. It has been agreed that it has been stated. Who's appearing for the state of Tamil Nadu?
I am appealing.
It has been stated on behalf of the state of Tamil Nadu by but that disbursement will be made to the judicial officer within a period of 4 weeks from the date of the raising of the bills. So for the states of Madhya Pradesh, Meghalaya, and Himachal Pradesh are concerned, compliance has been effected.
Your Lordship, if I may make a mention, to the state of Chhattisgarh, Your
Are
Lordship.
you any of these?
Yes.
Are you?
Chief Secretary.
Are you any of these 4 states? Bide your time.
We are compliant. That's what you said. Just
Right. So we have closed now so far as these 4 states are concerned.
Run through this list.
Sorry.
Run through this.
Bill for the state of Tamil Nadu, they have to raise a bill on whom?
Claims are to be made to the registrar through High Court, because these are allowances where the calculation has to be made by the officer, like how many children, education allowance, etc. So that bills have to be
The
submitted to
drawing and
the
disbursing officer has to note.
and then disbursing of
The claims have to be. I'll correct that.
But state of West Bengal is also released all
One
funds,
minute.
and now
One
only
minute.
bills have to be raised.
And sorry, the last part I think.
The state of, the bills identically will not, the drawing and disbursing officers have to raise the bills and all amount will be paid, which is balance.
Similar is the position in Arya also.
1 second, we take up West Bengal.
West Bengal. Bengal is they morning they have now filed. They have just shown me.
I've given an order, let's.
All the monies have been disbursed. So you all record that this make available all resources as soon as the bills are raised. Those will also be.
That order itself states.
Yes, shows the order.
Yes. I have a copy of.
in
In fact, I gave you the copy. In fact, the order says even if there is shortcoming, you pay it, it will be then later on.
Your Lordship's permit minutes.
What this order says, 26th August order says is this memorandum says is that the finance ministry has allocated the funds to the law ministry. So the Lordship sees from the above, it is evident that a necessary amount of fund has been released by the finance department for payment of arrear allowances on the basis of claim has been received. The judicial department has requested to reassess the exact requirement of fund for payment. Then you have with a detailed breakup, if any, and furnish the same to the finance department immediately, is what they say.
Now let's look at the next paragraph. First. It is however further directed that required fund is not available under concerned head. The treasury, as the case may be, will arrange for disbursement in anticipation of allotment. So even if there is some discrepancy, they will release the funds.
So we take this on the record.
There's just one, the lordship, just see page 6 of my note, my lordship. Just page 6 of my note. So far as West Bengal is concerned, one more item was pending. Para 22, page 6 of my note. By affidavit dated 19/8/24, the state of West Bengal, it is stated that allowances have been revised except for higher education qualification allowance, which is pending hearing in IA number 103071 of 23 minutes. This this IA minutes we couldn't look at, it's not there in the case status also. And in any way, there's no question of non-compliance so far as one allowance is concerned. So that also your lordship will actually clarify that para 41 of your lordship judgment of 4/1/24, 4th January 24 will have to be complied. 41, right?
Medical
43, 41 to 43. So far as higher education allowance is concerned. This IA we were not able to track at all.
Really, that's a.
That will be released also.
We have heard Mr. State of West Bengal, not in every state separately. पर वो state का नाम क्या रखना State of West Bengal, Mr. Rakesh Dwivedi, then senior counsel appearing on behalf of the state of West Bengal, tendered copy of the memorandum dated 26 August 2024, issued by the Finance Record Audit Department, the following terms. Copy kar lijiye and just scan it and copy. In view of the above memorandum, and the compliance which has been effected by the state of West Bengal, no further proceedings.
The bills, DDO will have to raise the bills, drawing and disbursing. Of.
Drawing and disbursing officer shall raise the bills within a period of
And they will, yes, and they will disburse immediately.
4 weeks, and the disbursement shall be made within a period of 4 weeks of the bills being raised. Next.
But the chief secretary and the officers are here, they may be exempted. And
Which your lordship's kindly.
we apologize for the delay.
So the problem is there's so many states have applied. The problem is when matters are called out repeatedly, the council are absent here. We don't know what to do then. That's the reason why we had to.
Chief secretary here will note your lordship.
We also have no great pleasure in calling the chief secretaries and finance secretaries here.
I
But
understand this.
consistently, we
Permission.
call out matters. Now they have briefed Mr. Dwivedi when.
Lord, even the state of Odisha.
Your lordship that.
All right, just 1 second. Mr. Rakesh Dwivedi has also assured the court that the payment of the higher education, the higher qualification allowance shall also be duly effected in view of the directions contained, shall be effected, full stop. The directions issued by this court in its order dated 4/1/2024, in brackets paragraphs 41 to 43, are expressly clear. And hence, the above payments against the above allowance shall also be disbursed.
The presence of the officers may be exempted.
Well, Lord, as far as the state of
Proceedings against the state of West Bengal, so far as this aspect need not be pursued any further.
Lord, as far as-
Just follow the matter.
Just 1 second.
Lord, in
Your lordship,
respect of
Now,
the-
now what we'll do is
Odisha.
page.
3 Odisha.
All right, who's appearing for Odisha?
Lord, I'm okay.
That's the reason why they were not compliant.
States.
1 second. Now let's see.
Of Tamil Nadu, are we presence of the officer?
Let's we close the proceedings.
To Tamil Nadu, my lord, there is one difficulty, my lord. Transportation charges are given only with the cars owned in the legal officers. There is some difficulty. The commission says the car owned in the name of the judge as well as of his spouse. But the order says only in the name of the judges. There is some difficulty with regard to that.
But so far as these individual grievances, there are about 100, there are about 100 grievances that have come up. In the last 2 weeks, I have received emails from different associations of judicial officers. The purpose of constituting a committee by your lordship's order dated 4/1/24 was for exactly this
Very
purpose.
grievances. We are now not required to look at the nitty-gritty of each individual. Yeah.
Ordered at that level. have not sat for the last 3. So at the end of today's orders, your lordship.
Just remind us that we pass that order to
that must sit.
the committees in the High Court should sit at least once every fortnight. What were you going to suggest? Once a month, well read, once a month.
The problems will just take care. Otherwise, these.
All right, just remind us before we rise, the matter is over today. Now, Odisha.
Odisha is concerned, your lordship, just kindly see page 8, my lords. What they had done was they had implemented your lordship's order.
Page?
Page 3, para 8, my lords.
Yes.
They had filed an affidavit stating that all the areas, etc., have been sanctioned. But if you just, the highlighted portion which is underlined, my lords, judicial officers from the state of Odisha also brought to the notice of the amicus that an office memorandum dated 29/2/2024 had been issued, mandating that actual disbursement of arrears shall be made over a period of 3 succeeding years. This was further clarified in May, my lords. A subsequent office memorandum dated 16/5/24 mandated that drawal of funds for arrears of allowances in 3 phases from 2024 to 2027. So this is why I had categorized them as a defaulting state, my lords, because your lordships had directed that all arrears should have been cleared by at least July 2024. So this now stands withdrawn according to an affidavit they have now filed on Saturday. That your lordships will get at page 4, para 10. So far as Odisha is concerned, since this was the concern that all arrears were to be distributed over a period of 3 financial years, my lords.
That is withdrawn. So we can close it now.
Lordship, just record this and then close it so that.
Yes. State of Odisha. An office memorandum was issued on 29 February 2024, mandating that the actual disbursement of arrears would be made over a period of 3 succeeding financial years, commencing from 1 April 2024. Stopped by a subsequent OM dated 16 May 2024. It was mandated that the drawal of funds for arrears of allowance in 3 phases it was mandated that the drawal of funds for arrears of allowance would be allowed in 3 phases from 2024 to 2027. Brackets 33%, 33%, and 34% respectively. However, an additional affidavit has been filed on behalf of the state of Odisha on 23 August 2024, indicating that the previous OMs dated 29 February 2024 and 16 May 2024, which mandated only partial withdrawal of arrears in phases over 3 years, now stands withdrawn. Of the additional affidavit has indicated that 44 bills remain pending for processing with respect of arrears of pay, pension, and allowance. Of this process shall be completed. The above bills shall be processed. Payments shall be made no later than within 4 weeks from the date.
May I just state that? Because these 44 bills have come only after the first affidavit was filed. There's an instruction by the state government to the treasury to make the payment because all the amount is with the treasury, the entire amount. So there's an instruction to pay within 3 days.
All right. Then last sentence you strike out, can say, Senior Counsel, then Counsel appearing on behalf of the state of Odisha, states that instructions have been already issued to the treasury of the state government to ensure that payment is made within a period of 3 days. The assurance is afforded. This was the matter. The proceeding against the state of Odisha, this aspect should stand closed.
Look, the Chief Secretary and the Finance Secretary are here in the court.
Do it on time and tell us when the matter is called out. That this is done. Yes.
Tamil Nadu is done, my lords. Page 4, Tamil Nadu is done. Page 5, Bihar was concerned, my lords. Your lordships had recorded the oral submission made by the council on 11/7, para 18. The council appearing to the state of Bihar. I'm just quoting from the relevant portion of the order dated 11/7. The council appearing to the state of Bihar states that an amount of rupees 122 crores has been transferred to the Law and Justice Department and the payments are being made in full compliance of the orders of this court. What we did, we circulated a questionnaire to all states so that they can upload the relevant documents and also answer on the questionnaire. Bihar did not respond to that, no affidavit also filed. Now they have filed pursuant to your lordship's last week's order summoning the chief secretary's minutes. They have now filed an affidavit stating that they are in full compliance. The reason why Bihar was earlier classified as a non-compliant state was they neither responded to the questionnaire. We circulated an online questionnaire so that specific answers could be obtained.
Who's appearing for this?
My lord, I am appearing for the state of Bihar. My lord, the compliance has been made. It's only because the affidavit was not filed.
State of Bihar. Bihar Board essentially. On 11 July 2024, the following statement of the council for the state was recorded. Convert from us. ये Commissioner जी के note में 18 में copy कर लीजिए quoted portion. Pursuant to the above order, a questionnaire was circulated by the amicus curiae seeking an update on all aspects. Since the state of Bihar did not either file a response to the questionnaire, nor did it file any affidavit until 24 August 2024. It was classified as a defaulting state. However, on 24 August 2024, the state has tendered an affidavit, filed an affidavit indicating that it has fully complied with the orders of this court with respect to division of pay, pension, and allowances. But the allowances were revised by a resolution dated 28 February 2024. Stop. It has been stated that all the claims made in respect of the arrears of allowances have been disposed of. In view of the above compliance, the proceedings against the state of Bihar, so far as the above aspect is concerned, shall stand closed.
Personal appearance may be discussed.
Personal appearance is Har ek mein personal appearance is dispensed.
Page 6.
Now we've got
page 6.
one
West
second,
Bengal
I'll
is
just
done.
keep on ticking now. Now we are dealing with Kerala.
But so far as Kerala also is concerned, the same Odisha technique was employed, saying that we have cleared all bills, but there will be a lock-in period. Well, Lordship will kindly see para 24. In respect of payment of arrears of allowances as per geo dated so-and-so of 4th March 2024, arrears of allowances were to be credited subject to the condition that the amount could be withdrawn only after a lock-in period of 2 financial years. Further, arrears were to be disbursed in 3 installments of 6 months each over a period of 2 financial years. Now on 20th, my lords, they have now withdrawn this after we pointed it out to them that this lock-in period was not lordship's orders. They have now withdrawn this lock-in period. But what has happened, my lords, is that pursuant to the March 24 order, they transferred all these amounts wherever they were cleared to a number of judicial officers to their PF account. And that PF was to be touched only at the time of retirement. So that transfer has already happened so far as compliance with the 4th March 24 orders was happened. So your lordship will have to direct that wherever those transfers have happened to the PF account, we'll have to go back to the salary account. So after all arrears, how can arrears be deferred, Manos? And that too for allowances. So medical allowance, DA, etc. They credited it, but they said we'll credit it to the PF account so that you can't utilize it until you retire. The entire purpose of giving allowances and arrears is defeated.
Lord, Lordship, with permission, I'm appearing for the serving officers, Your Lordship. Lot of other animals also there, Your Lordship. I will file a response for that. I'm appearing.
I'm appearing for the state, my lord. We accept the position, my lord. We are in the process, my lord, of transferring it from the PF account to, my lord, the salary.
Lordship, not only that, Lordship, lot of other problems also there. Let me, I am appealing for the.
Before the Supreme Court, we are not going to deal with individual grievances like this. Therefore, we have institutionalized the process. We have constituted committees in the high courts to deal with this. We are dealing now with national issues where there was an overall non-compliance. Individual issues placing before the committee, we are going to pass an order. Rest assured, we will not leave you in the lurch. You are our judicial officers. So we will not leave you in the lurch. We'll pass a general direction for these kind of grievances. Don't worry about it.
Please, Your Lordship, only consider the grievance what we are pointing out. That's only, Your Lordship.
Court will be more interested in
Don't worry, we'll deal with it.
Pass the usual order as far as the persons are. But they are here. The chief secretary.
Yes. Kerala. By geo. Just 1 second, ma'am. By geo number 66/2024, home dated 4 March 2024. Kerala had directed that arrears of allowance would be credited subject to the condition that the amount could be withdrawn only after the lock-in period of 2 financial years. Moreover, the arrears were to be disbursed in 3 installments of 6 months each, spread over a period of 2 financial years. However, a subsequent GO dated 20 August 2024 has rectified the anomalies which were pointed out by the Registrar General of the High Court respect of the various allowances. The GO withdraws the lock-in condition and the condition for disbursal of arrears in 3 installments. Mr. K. Parmeshwar, the amicus curiae, further has pointed out that that where the amounts were credited, the credit was made to the PF accounts of the individual officers, which would effectively mean that the availment of the arrears would stand deferred until the date of retirement. Mr. Jaideep Gupta, then senior counsel, appearing on behalf of the state of Kerala, has stated in response to the above submission that the state of Kerala has already taken steps to reverse the position so that the amounts which were credited to the PF accounts would be retransferred to the salary accounts of the judicial officers. The GO also states that the GO dated 20 August 2024 states that disbursement of arrears would be made as and when bills are presented. Full stop. Following the full stop. The bills shall be presented within a period of 4 weeks. Full stop. The disbursement shall be made on or before within a period of 4 weeks from the date of the presentation of the respective bill. The proceedings in respect of the state of Kerala shall accordingly stand closed and personal presence is necessary. So we are done with now Kerala, which is the next state.
UT of Jammu and Kashmir. For their concern, there is no revision that has happened of allowances, not just payment. Revision of allowances has not happened. Therefore, consequently, payment of arrears also has not happened. So their response
serious problem.
So they say that the union government has to sanction the revision and the arrears are concerned. The union government had filed a review petition before your lordship, which your lordships have now dismissed on 31st July 2024, so far as all union territories are concerned. So there's no question of now relooking.
We just hold back Jammu and Kashmir and Ladakh for a moment. Now, what about Delhi? What about Delhi?
Yes, goes for UT of J&K and Delhi. That was the problem. Now, since the review is dismissed, with the
So Jammu, Kashmir, Ladakh, Delhi, all of it await union permissions. So all of them await union permissions.
union concurrence was required. Now, since review is dismissed, we have
The Jammu and Kashmir, Ladakh, and Delhi. Mr. K. M. Natraj, then the petition seeking petition seeking review of the judgment of this court dated
4/1/20.
for January 2024 into brackets review petition number
970 diary 29704 of 2024.
has been dismissed by an order dated
31st July.
31 July 2024. Next, Mr. K. M. Natraj, learned Additional Solicitor General states that in view of the dismissal of the review petitions, necessary permissions will be issued by the Union of India within
at the earliest about 6 weeks.
At the earliest, 4 weeks. Full stop. All disbursements shall be made to the judicial officers within a period of 4 weeks
Thereafter.
Proceedings against the above states, above duties are accordingly closed.
Great.
So Delhi is, just 1 second, let me take, Delhi is done. Then we have done Jammu and Kashmir. Jharkhand.
So far as Jharkhand is concerned, Malak, the affidavit, if your lordships kindly see para 35 and 36 plus, they are 90% compliant on pay, pension, etc. On so far as arrears is concerned, Malak, the affidavit was silent on what was transferred to the relevant district headquarters and how much was actually disbursed. So following the West Bengal order your lordships have now dictated and the Kerala order your lordships have now dictated, your lordships can say that whatever remaining amount is there so far as Jharkhand is concerned on payment of allowances, Malak,
bills will be raised within a period of 4 weeks and they will clear it within a period of 4 weeks.
District judge himself is the one person.
DDO in a lot of states, this is the problem because the funds are being made available to the law department, Malaj, because since the principal district judge is also the DDO, district disbursement officer, Malaj, raising of bills has occasioned, because of the delay in raising of bills of allowances, funds could not be transferred. So for Jharkhand also, your lordship will could pass the same order as West Bengal and Kerala, saying that they will make available the funds. And that
on behalf of the state of Jharkhand, an affidavit has been filed on 17 August 2024. The state of Jharkhand has stated that payment of arrears of pay has been cleared for all judicial officers. The majority of the officers has been paid the arrears of pension. Except for 7 allowances, the rest of the allowances have been approved on 19 July, 8 August, and 13 August 2024. Council appearing on behalf of the state, Senior Council appearing on behalf of the state of Jharkhand states that the district judge is the drawing and disbursing officer in the state of Jharkhand. Good stop. Next, to facilitate payment to the judicial officers, it is directed that the drawing and disbursing officer shall raise their bills within a period of 4 weeks from the date of this order. Good stop. All right, we'll say that the concerned judicial officers shall make their claims, place their claims before the drawing and disbursing officers within a period of 4 weeks from the date of this order. Good stop. The payment shall be made within a period of 4 weeks. Within a period of 4 weeks of the lodging of the respective claims. So, proceedings closed. So now we conclude Jharkhand. Then what about
Andhra Pradesh? Dated 20th August 24. It sought for
only order for dispensing.
Yes, that we dictated earlier, so we are doing that.
Para 39, Malaj. Para 39. Or in the affidavit dated 20th August 24, a period of 4 weeks is sought for clearing of pending bills. The same orders may be passed, same like.
My lords, the same issues with the DDOs arise. Therefore, the same order as was passed in the case of Jharkhand.
There was some technical hitch, my lord, of uploading bills.
That has been addressed. That has been addressed and payments have been made subsequently.
Para 39, in its affidavit dated 20 August 2024, the state of Andhra Pradesh has got a period of 4 weeks for clearing all pending bills. And then the same order as in the case of Jharkhand, drawing and disbursing officer. Is that district judge the drawing and disbursing officer?
The case may be whether, depending on the grade of the judicial officer, whether they are in high court or a
Don't
district.
say the district judge is a
DDO, my lords, could be in the high court or the
high court.
district court.
The DDO to claim shall be made period of 4 weeks to that drawing and disbursing officer, and thereafter within a period of 4 weeks.
4 week payment.
Andhra is done.
Madhya Pradesh and
Andhra Pradesh
they
High
were
Court.
compliant.
May I say this?
1 second. Madhya Pradesh has complied. We had already passed a general order for Madhya Pradesh.
Chhattisgarh, Malaj, only 4 allowances were remaining. Malaj, para 46, if your lordship just reads the highlighted portion, underlined portion.
All right. Now, who's appearing?
Your Lordship, I'm appearing for Chhattisgarh. Your Lordship, the state has sufficiently allocated all the budget to the district, to the high courts, and high court has equally disbursed all the money. We have also put in the proof of payment, which is marked as an annexure in the new affidavit, which has been filed on 24th. And as per the instruction I have received, as on date, there are no bills pending with the treasury, Your Lordships.
In the 24th August affidavit, Malaj, for lordship, may I just place para 46. By the affidavit dated 24th August 24, it is stated that information was received by the state from the High Court regarding disbursement of allowances. The High Court has stated that sufficient budget has been allocated by the state and the payments are being processed by the High Court as per submission of bills. A chart prepared on the basis of the information received from the High Court is annexed at page 702 of volume GG. The chart indicates that arrears in respect of 4 allowances are in the process of being paid: concurrent charge allowance, higher qualification allowance, telephone facility and hilltop area allowance. These are not being paid, my lords. The Judges
not-
Association also say.
Your Lordship, with regard to those 4 allowances,
Okay.
whatever bill has been put on, so till date has been cleared. So as and when the bill will be put up, the same will be cleared.
Lordship, just grant them 4 weeks and ask them to clark these 4 also.
Appearance note, sir. In its affidavit dated 24 August 2024, the state of Chhattisgarh has stated that information was received by the state from the High Court regarding the disbursement of allowances. From the High Court stated that a sufficient budget has been allocated by the state and payments are being processed by the High Court as against the submission of bills. Stop. The amicus curiae, however, states that it appears that arrears in respect of 4 allowances are still in the process of being paid. Charge allowance, higher qualification allowance, telephone facility, area allowance. Learned Counsel appearing on behalf of the state of Chhattisgarh states that the payments would be made as soon as bills are received. We direct that the exercise be completed within 4 weeks.
Your Lordship, the payments has been made. Any further bill which will be put up, the payments will be made.
Learned Counsel of the state of Jharkhand stated that while payments have already been made, any further payments which remain due would be made within a period of 4 weeks of the receipt of bills. The statement on behalf of the state of Jharkhand is accepted. Chhattisgarh is accepted. Compliance be effected in the above terms. The Registrar General of the High Court shall monitor compliance. And the event there is any further difficulty, bring it to the notice of the committee of judges constituted by this court by its order dated 4 January 2020.
Your Lordship, personal presence of.
Yes, we are closing.
Will be
Yes.
exempted.
Yes.
Please oblige.
My lords, my lords, in case of Andhra, the presence of the Chief Secretary and Finance Secretary may be required.
Yes, we already closed it. Yes, that's a standard order for all states where we are recording compliance.
Lordship, the notification, Lordship, has been issued on 12th of August, and then Lordship on 16th of August. It's also noted in the note of learned amicus. On 16th of August, Lordship, the entire budget has been made available. It's Lordship now for the DDOs, Lordship. There are 204 DDOs who are basically, Lordship, in the High Court and in the subdivisional courts, Lordship. Whenever, Lordship, the bills will be raised, Lordship, within 4 weeks, Lordship, we can make the payment will be made. The funds are available, Lordship. To contradict. Is not good enough.
What we will do is, we will keep it after, we will keep it, you first tell us when are you going to, when is the money going to be disbursed?
Lordship, the money is made available, Lordship. It is now, the process that happens is that the DDOs, Lordship, will raise the bills, Lordship. As and when they raise the bill, within 4 weeks, we will disburse the money, Lordship. The money is available. Even in the note of the amicus, Lordship, it is.
Where is said that the budget is being made available? Where is the money lying right now?
Have you transferred it to the treasury?
Actually, the money will be.
Have you transferred it to the treasury or not? For the purpose of disbursement, where is the secretary? Where are they? Ask them.
Has the money been transferred to the treasury, sir?
So then make a statement accordingly.
Then that's all right. Then we'll, state of Assam, then counsel appearing on behalf of the state of Assam and the chief secretary
And the finance secretary, both of them are present, Lordship.
states that on 12 August 2024, a notification has been issued by the state government, and necessary budgetary allocations have been made on 10 August 2024. However, it has been stated that there are 204 drawing and disbursing officers, the state, and as soon as the bills are received, payment will be made
within 4 weeks.
Within 4 weeks.
Well,
Say you can say the same thing.
well, I'm representing the Assam Judicial Service Officers Association. Although the notification has been issued on 12th of August, well, so far as the risk allowance is concerned, they have confined it only 10%. as against entitled 30%. That may be, my lord, the recorded, because we are entitled to 30%. The other civilian employees are given 30%.
Anyway, if they have a grievance, they can move the High Court.
Yes, Lordship, let them.
This is a overall thing we'll close here. Yes.
That may be recorded in the order, my lord, that in case of any grievance relating to the percentage, we may move the High Court.
Of course you can. By a previous order, therefore we have constituted that committee.
Lordship, at the end of this order, just reiterate that portion because we are
Any other remaining
flooded with.
Just remind us before we close.
We are being flooded with these individual allowances where there are tweaking. So your Lordship may clarify it at the end.
Lordship may dispense with the appearance of the.
Yes, yes, of course.
Oblige.
Paragraph there which I've extracted at para 51 of my note, however, clarify that this amount does not include pension, family pension, and pension areas to the retired judicial officers. If your Lordship just clarify.
Your Lordship, the amicus has circulated a questionnaire where we have given proof where it has been given. Now, in the state of Nagaland, insofar as the pensioners are concerned, it goes to the treasury directly from the accountant general, which is why we are not being able to give the exact amount, how much has been disbursed. That is the only clarification that we have given. Otherwise, the proof has been given that the pension as well as the arrears have been paid.
I am representing the Nagaland Judges Association. Well, 3 allowances are not being given. Number 1, RICS allowance is not being given.
Which one?
Medical RICS allowance is not being given. They want clarification on that.
Para 53.
Your Lordship, we have filed an application insofar as the risk allowance is concerned.
All other states, northeastern states have been given the RICS allowance. Why not the Nagaland?
Your Lordship, we have filed an application. Our application is at page PDF 238 of the volume GG that the amicus has circulated.
Two applications. This kind of, if allowance is being given to other civil servants, Nagaland now say that its civil servants, although it's an insurgent affected area in some parts, its officers are not getting, civil servants are not getting it. So therefore, judicial officers are also not entitled to get it. The Lordship's order was very clear.
Very clear.
Officers will be entitled at a rate applicable to civil servants. If civil servants are not getting it, and that's the standard of the state of Nagaland, then therefore judicial.
We have annexed the opinion of the AG also.
Then if they are not, if civil servants are not getting it, then the
Yes, Your Lordship. That is why the clarification has been filed.
No, my lord, your Lordship will kindly make an inquiry. The civil servants are getting the allowances so far as the All India services are concerned. They are getting it at the rate of 30%.
Your Lordship, I have annexed the opinion.
That will be a misleading fact, my lord.
This issue may be left to the committee and then your Lordships will have a view on this. Otherwise, this application, clarification, there are 7, my lord.
Let it be.
There are 2 other allowances, there's a problem with it. Now, if your Lordships are to go into all 3 allowances here, then this entire business of the committee will, or this IA for clarification, the committee will look at and decide about these 3 allowances.
Your Lordship, may I be permitted to submit?
Find some solution. The state of Nagaland, in its affidavit dated 16 August 2024, the state of Nagaland has stated that arrears of pension have been cleared, semicolon, full stop. Moreover, amounts of rupees 4 crores and rupees 9.32 lakhs have been released on 15 July 2024 and 25 July 2024 for the payment of the arrears of allowances. So far, the state has made payment up to rupees 10 lakhs, right?
10 crores, Your Lordship.
Is it 10 crores in your para?
I would have lost it.
Your Lordship, it cannot be 10.
It has made payments of rupees 10 crores. However, the state has however, the further statement is in the following terms. Colon, इनके note में para 51 में ले लीजिए.
That's 10 crores, my lord.
10 crores, yes. No risk allowance. Council appearing on behalf of the state of Nagaland states that
no risk allowance has been sanctioned for the reason that the civil servants are not receiving it.
Yes, Your Lord. In fact, this issue was brought up with the.
Well, that is not correct, my lord. May I clarify that position is not correct.
The moment you start speaking, you will start retorting. So we'll find an answer.
Your Lordship, the committee had.
Discretion lies in just keeping quiet. They're protecting you. Just 1 second. The statement made on behalf of the state of Nagaland is, however, disputed on behalf of the judicial officers. It is disputed by Mr. B.K. Sharma, Learned Senior Counsel, appearing on behalf of the judicial officers of the state of Nagaland. In order to obviate any difficulty, we leave it open to we direct that the committee of judges constituted in pursuance of the judgment of this court dated 4 January 2024 shall verify whether the payment of risk allowance is being made to civil servants. To stop, the order of this court clarifies that payment of risk allowance shall be made at the same rate as is paid as is made to civil servants.
Civil servants.
Para 68 and 60.
Well,
Your Lordship, may I pray that
well,
the
maybe
payment clarify.
permitted
In
to
case
point
there's
out
no
two more
payment,
things.
then the state will not require.
Whether any risk allowance is paid to civil service officers in the state of Nagaland is a matter which should be verified by the committee. Full stop. In the event, it is clarified that in the event that no risk allowance is paid to civil service officers, there would be no obligation to pay to the judicial officers.
My lord, may I point out, my lord, two things, my lord. Your Lordship may edit, my lord. So far as the medical allowance is concerned, reimbursement, etc., has not been mentioned in the order. As to how it will be reimbursed, nothing has been mentioned. And so far as the higher educational qualification allowance is concerned, they say it will be only one time. If I'm LLM, I'll be entitled.
Mr. Sharma, please read our order. Therefore, we made a provision for the disbursement of medical allowances and medical treatment.
Standard operating
But they are silent, my lord, about the reimbursement, etc. They are silent.
You go to the
And
High
secondly,
Court.
higher educational qualification, they say it will be only one-time increments. Subsequent promotion, ACP, etc., will not get any increment. The notification says so, my lord. Is it so, my lord? That was not the intention, my lord. The lordship is clear enough.
They say whether judicial officer is entitled to grant of advance increments for acquiring higher qualification during every promotion or grant of ACP.
Yes.
So that's also covered para 40.
That they have denied, my lord.
If they have denied, then that must be challenged. But what else can I say? Because your lordships,
Well, in the event that there is any further difficulty in the disbursal of the arrears, in the disbursal of advance increments for acquiring higher qualifications, this may be drawn to the attention of the committee of judges constituted in person for the order dated 4.
Your Lordship, may I just place on.
Including the
This
medical allowance
actually
issue,
was
my lord.
brought-
Medical allowance issue also.
I have
Including the
annexed
medical
the
allowance
minutes of meetings dated 5th August 2024. This was discussed. They were not able to resolve it, which is why the finance had actually written to the registrar saying approach this honorable court for clarification. The issue is this, Your Lordship. Your Lordship direction says that 3 advance increments should be given once they acquire a higher qualification and +1 if they get a doctorate. According to us, we've already given that. Now, what the officers are saying is that every promotion they should be given that 3 increment again. This is a controversy, Your Lordship, and this is a genuine obstacle that the state is facing because we have already given.
They've already given it.
Yes, Your Lordship.
They are now saying that for every
Promotion they need to be.
The normal increment, madam, not the additional increment, normal increment. They say that once you are given 3 increments on attaining the higher educational qualification.
Granted the first ACP. At the first ACP, all their colleagues are entitled to 1,000 rupees. Just giving an illustration, the advance increment is 100 rupees for higher education qualification. So they get 1,100 instead of 1,000. Now the next ACP, my lords, they are all placed at 1,500. So the officers who are claiming this higher education allowance now say that our edge is lost because all of us in the next ACP have been put at the same bracket of 1,500. So we should get it 1,600 also at that point of time because we have actually worked on an LLM and a PhD degree so that we are entitled to the advanced higher education qualification advance. So ACP is almost like a matter of because they are otherwise not promotional opportunities, almost as a matter of course. So they say this edge is lost every 5 years. We are granted the ACP because then all of us become par at the next.
It's a one-time payment.
Yeah, that's the opinion of the finance department.
No, the judgment is very clear. Judgment says that advance increment.
One minute. Lordship, just kindly just see the judgment para 41 to 45.
That may also be gone into by the committee then.
In this case, she is right when she says that the committee has gone into it. They were not able to resolve it. Therefore, they've filed.
Let's see what paragraphs 41 to 43 state.
Yes.
SNJPC notes that for acquiring higher qualifications in law, specialized study of the subjects concerned is involved, and the acquisition of such qualification, the nature of a postgraduate or doctoral degree, will improve the quality of work of a judicial officer. The recommendations of the SNJPC are summarized below. The para 42. The recommendations made by the SNJP is that the benefit of advance increment shall not be extended at the ACP stage appears to be covered by this order of this court dated so and so so and so. There is no justification for denying the benefit of advance increments at the ACP stage. The object and purpose of ACP is to prevent stagnation. On the other hand, the object and purpose of advance increments for requiring higher qualifications to improve judicial performance. Hence, the restrictive condition imposed by the SNJPC in regard to the non-extension of advance increments at the ACP stage is not accepted. The advance increments for requiring higher qualifications shall also be made available to officers who have acquired the degrees through distance education.
So we said even at the ACP stage.
Yes.
For the clarification now, they get first ACP, they get it. Second ACP level at 1,500. So at that time also they must maintain their edge.
Different states are interpreting it differently. So, my lord, I suggest we will just collate it and give it, because this is not a problem only related to this state. Different states are doing it in a different fashion. So this is a problem across the board.
Promotion also it has
As regards the grant of advance increments for acquiring a higher qualification, Learned Council appearing on behalf of the state of Nagaland states that the directions contained in the judgment of this court dated 5 January 2024 have been duly complied with. However, the issue as to whether the advance increments to be granted at every stage of the every ACP stage was placed before the committee of judges of the High Court but could not be resolved. Hence, an application for clarification has been filed before this court. Full stop. Both Mr. the learned amicus curiae and Mr. Gaurav Banerjee, appearing for the judicial services, both the amicus curiae, Mr. K. Parmeshwar and
BK Sharma, I am appearing for the
on
judicial
behalf of the judicial service associations, state that this is an issue which concerns other states as well. Full stop. They have agreed to. They have stated that they would prepare a compilation of the position as of the manner in which implementation has taken place of the directions contained in paragraph 43 of the judgment dated 5 January 2024, so that comprehensive directions pan India can be issued. Full stop. The issue in regard to the payment of the advance increments for higher education allowance as regards the state of Nagaland is therefore deferred and would be dealt with on a pan India basis.
Oblige, your lord.
Sir, may I just clarify?
Right. So now,
Apart from ACP for post graduation also for a promotion also it has been still be
covered by
the same
be
ACP.
covered by the same order.
Covered by this order.
Your lordship,
But Miss, we are prima facie of the view that this must be granted at every ACP stage also. It was not like a one-time incentive. We'll see. Promotion you have stopped.
we're just,
Then
we've
we'll
just
resolve.
given one time
Doesn't
and that
matter,
is
we'll
a
resolve it in a short order. It's not a very major thing.
pleasure.
What
Your
is
lordship,
left
the,
is only
the
Now
chief
what-
secretary and the finance commissioner are also
Yes,
present.
expensive, yes.
Like,
Plus Meghalaya is done, Himachal is done, but what is left is Haryana. Haryana only one aspect, that's para 60 at page 14. State of Haryana in its affidavit dated 20th August 24 had stated that it is issued necessary GOs revising pay, pension and allowances. The affidavit stated the following. Further stated that domestic help allowance, medical allowance, your lordship will kindly note that, are not extended by the state government to any new pension scheme retirees. So what they did, so far as all the other concerns are conditions are concerned, they have met. Pay, pension, areas, all that has been met. But these two allowances, they are saying if judges start retiring under the new pension scheme, they will neither be entitled to medical allowance, nor will be entitled to domestic help.
You have to grant this. What is this?
As far as this part is concerned, my lords, my instructions are, my lords, because this issue specifically, my lords, this is pending consideration because, my lords, old pension scheme, whether.
But this is independent.
My lords, we are already giving it to all the serving judicial officers. We are giving it to the retirees under the old pension scheme. As far as the retirees under the NPS, my lords, for that thing only, my lords, there is a little ambiguity, my lords. With respect to this, my lords, we are saying that whether they will fall.
No other state has this problem.
We'll keep pending.
My lords may decide this issue one way or the other. This
We'll decide it with the.
Yes, my lord may decide this one.
We'll decide this issue with the
quickly.
pension scheme. The state of Haryana, in its affidavit dated 20 August 2024, has stated that it has issued those for revising pay, pension, and allowances. The affidavit, however, indicates as follows: Para 60 में copy कर लो. We take on record the assurance that all other allowances, except for the domestic help allowance and medical allowance, have been paid. They've been paid, no?
Yes, my lord. They have also been.
Stated that the retirees under the old pension scheme have been paid the domestic help allowance and medical allowance also.
Please, my lord.
The issue, however, pertains only to retirees under the new pension scheme. Since the issue in regard to the applicability of the new pension scheme is pending before this court, we defer further consideration of this aspect.
I just wanted to add something.
Yeah.
The new pensions has now acquired certain dimensions.
We saw
So
the
that
other day.
you'll not defer it for the time being, so that none of those issues are taken up.
We
Very
Lord may decide this issue of old pension scheme
That's all
in
right.
one way, so that Lord, this is decided.
Right.
I don't think this tweaking will really help. No.
All right. So now that is Haryana. Now, Odisha compliance is over.
All is done.
Now we have to, yes, the appearance is dispensed with, no difficulty. Now,
Commission recommendation came in 2007 is when 99% compliance was recorded. We are much better in terms of the record. 22, your lordships accepted the first set of recommendations. In 24, we are at least 95% compliant. Petty Commission took 99 to 2007, one after the other, coaxing the states into complying with the recommendations your lordships approved. Took 8 years then. The second NJPC has taken much lesser time.
yes.
2 years time.
Now, what are the general directions that we have to issue? We will say that the present order has dealt with the issue of compliance with the directions contained in the order dated 4 January 2024 and the previous order. Full stop. Or from the above directions, we issue the following general directions: bracket 1. The event that any individual grievances subsist of judicial officers in any state, this may be brought to the attention of the committees of the judges of the High Court, constituted in pursuance of the order dated 4 January 2024. That's one.
In respect of specific allowances, there are disputes that may go to the committee. There are specific allowances partly implemented, not implemented.
This one above, the direction in one above would also cover any grievances in respect of specific allowances, which should be resolved at the level of the state stroke duty concerned by the committee of judges.
Whereas problems that our officers are facing in terms of withdrawal, etc. Your lordships had issued specific directions in para 85 and 86 of the judgment dated 4/1/24. The lordships will say that the high courts will make that compliant because your lordships have directed them to have standard operating procedures, put it on the website, say how well they can medical
paragraphs
85 and 86 pilots. Those directions, if your lordship will just reiterate.
High Court, the committees of judges in the high courts constituted in pursuance of the order dated 4 January 2024 shall in particular ensure that a standard operating procedure as mandated in paragraphs 85 and 86 of the order is duly put into place any event by 30th September 2020.
Who said that lordships will direct them to meet at least once a month or a fortnight?
The fourth, in order to resolve all pending issues in regard to the payment of pending issues pertaining to the grievances of the officers, any subsisting issues regarding the grievances of the officers in regard to the payment of allowances, we request the committees constituted by the high courts to meet once every month so that the grievances are resolved expeditiously.
I filed an application seeking your lordship's permission to recommend to the government for increasing the retirement age to 61.
To get into that, you can always do that, but you require us to give you liberty.
Because of the
the government employees age is Telangana. High Court
has come down.
after the government for your lordships and saying that the judicial officer
in
Telangana. But that was with the concurrence of the government. The High Court, the judicial officers, and the government was divided because, and your lordship also agreed to it immediately. Those
I remember that order.
Although this commission recommends any increase in retirement age,
Because the government was willing to do it.
Can I just take a minute to?
Andhra.
In Andhra, the benefit of the increase officers, there are two reasons why it ideally should be. One, at the district judge cadre, we are now facing an extreme crunch. We don't get enough officers every year for recruitment across your lordship's knows that. Two, all the special courts that the different statutes mandate are all district judges. POCSO, CBI, politicians' courts, MPs, MLAs courts are all manned by district judges. So it is something that will actually benefit the system if we increase the retirement age by a year.
No reason why the High Court should not take it up with the state.
So the High Court agrees with it. The question is whether the state will now agree with it. Your lordship.
My lord, we have no problem.
State asked us to send a recommendation.
My lords, if I may explain what has happened. The state had carried out an amendment and increased from 60 to 62. That was set aside by the Honorable High Court in light of my lord's judgment. My lords, therefore, now, as of now, the age is 60. If my lord, for the retirement of judicial office. My lords, if my lords consider the application of the High Court may approach us and we will consider it in due course. My lords, it is a policy decision and a legislative amendment which must be carried out.
The High Court
You are appealing for the High Court?
Yes.
But why did we set aside the decision of the government to increase it from 60 to?
No, that's for the civil service, not for the judicial office.
No, my lords, no. For judicial officers, it was increased from 60 to 62. Vijay, an order dated 16/9/22. The Honorable High Court, relying on my lord's judgment in the 4th All India Judges case, says 62 due to hierarchy of courts. The retirement of a district judge at 62 is not permissible. Whereupon Telangana carried out an amendment, made it 61. High Court approached pursuant to the amendment. In Andhra, there is no 61 amendment, which is why
So now, therefore, there's really nothing. Okay. The High Court can certainly approach the government of Andhra to increase it from 60 to 61.
State government, High Court recommendation.
for amendment.
Right.
Now, because of the judgment of your lordships, the High Court thought it fit to seek permission of your lordship.
We quashed the increase from 60 to 62, right?
Yes, ma'am.
Does our judgment prevent the government and the High Court from increasing it from 60 to 61?
My lords, in the state of Telangana, that amendment has been upheld by my lords. In state of Andhra, that amendment has yet to be done. We are only asking that the matter may take its due course in amendment. We may be permitted to consider it, my lord. Lordship,
Why do you require us to give you a stamp of approval? Let the High Court do it. The Chief Justice to do it. Why should something that the Chief Justice themselves have to do? Why do you have to be so? Look, that said that 62, from 60 to 62,
My
because
lord.
there has to be some difference to be maintained.
My lord.
Now, 60 to 61 is affected in the case of Telangana. That has the imprimatur not only of the states and the high courts, but our imprimatur also. Now, similarly for Andhra, if you want to submit a proposal to the state of Andhra Pradesh, please do it. Please tell Justice Thakur to send it across to the state government. We have no difficulty. But you don't require, I don't see why we have to certify that you can do it. Do it. Who's going to oppose it? It can be the state government. It can be the judicial officers. So long as it is something short of 62, why should we stand in the way? Especially because the Telangana judicial officers have got it. Right? All right, now there's no confusion. Have a word with the learned Chief Justice. Right? You can show him the order which was passed for Telangana. Ma'am, why don't you do this? Just share the order which was passed for Telangana with the learned Registrar General.
Even my lords, however, they are aware of it. And they are aware that it's supposed to
You don't require us to. All right, so this part is over now.
Also, your lordship, that the suo moto as the High Court judges' salaries and the fixation of High Court, a number of issues. So I have just put in a note, that some of those.
Do we take it up today or do we take it up?
Lordship will just adjourn these matters because pleadings are not complete. Just kindly takes the note for a minute, Milords. There is a horizontal. I've just made it easier and put one vertical and one horizontal.
Yes.
This is an entire batch of matters connected with the suo moto. On the last occasion, your lordship had issued notice on the suo moto. There are 3 matters in which I have indicated formal notice has not gone, pleadings are not complete. Your lordships will direct
those.
Item number 5, 7,
and
15.
5 is refixation. 7 is Singh, right?
Right.
Just Singh Yadav.
Right.
And 15 is refixation of pension, additional pension. So we'll issue notice. They are on board today, right?
They are all on board.
We'll issue notice. Returnable on Kato. After 2 weeks?
2 weeks.
4 weeks.
Pleading be completed.
But this can be detached from the All India Judges because this is High Court pension.
Detach this. These are High Court pension matters. Okay, and detach it and we list it separately.
There are 2 employees matters which have also come in the list today. That also will be detagged and your lordship can call it.
Can you just give him the?
We'll give the numbers. We'll give the numbers.
Employee matters detached kar do, wo alag list hai. We'll take it up. Yeah, we'll take it up.
The lordship.
There is 1.17.
That is in this one. The High Court judges fix it.
1.2.
This is also the High Court judges in the same batch. High Court, Mr. Dwivedi is appearing in
1.17, no, it's a pension matter. Lord, just claiming the benefit of the judgment of your lordship already delivered in
again,
Rahul Garg's case.
High Court judges, my lord. So there are 3 or 4
have been issued in that matter.
Yes.
The union is contesting. There are 3 or 4 sets of matters in the High Court judges case. One, additional judges who were not made permanent, died in office, family is not getting pension, number 1. Additional judges, if they don't complete the requisite qualification as of qualifying years of service as a High Court judge, whether they are entitled to pension at all, number 2. District judges who are under the new scheme, new pension scheme going as High Court judges, which is the lead matter your lordship took suo moto cognizance of, because he was not entitled, the gentleman there was not entitled to pension as a district judge because he was under the new scheme. and he became a High Court judge. Even after retirement as a High Court judge, they are giving him the same new pension scheme pension and not the pension that otherwise High Court judges are entitled to. So there are 6 or 7 issues. I have tabulated them, in each one. What is the issue? Lordships will have it because the union is contesting each one of them.
No. In my case, it's squarely covered by the judgment. There's no question of contest. It's on all four.
I know, but we'll have to hear the other side. Right? Who's appealing for the?
My lord, may I need 30 seconds, my lord? My lord, may allow me 30 seconds, my lord? My lord, may allow me 30 seconds, my lord?
Lordships have interpreted part 3. We are claiming this benefit as interpreted by Lordships. The other thing, Your Lordship
Can
said,
we detag that matter and then hear that? And just detag that and keep it on another day, on a Friday. We'll see then. So we doesn't get lost in this big bunch.
4 paragraphs, the Lordship judgment have to pay.
We'll keep it either on next Monday or something.
May I seek my lordship permission, my lord? To mention item number 1.2 to 1.6, my lord. In one of them, lord, the petition of R.P. Mishra, my lord, who's not getting salary for the last 9 months. My lord. He's a sitting judge of Patna High Court, my lord.
Right. We are keeping all of them together, and we'll keep it because there are some matters where notice was not issued. We'll hear it together in 4 weeks and solve it.
My lord, what is happening is not getting salary for the last 10 months.
Same problem. Salaries.
He's a sitting judge of the Patna High Court.
What the concern is this? They are saying does not have a GPF account, therefore he is not entitled to salary. It's a very weird case, Mullahs. They are saying these are officers who are under the new pension scheme. They are working
Besides that new pension scheme, take away all this will be over, my lord.
Because they are saying because these are sitting judges, judicial officers who were born into the new pension scheme. They don't have a GPF account, therefore we will not transfer salaries also. This is sitting judge of the Patna High Court.
What?
Your lordship decides that matter, all this will
I am seeking
fall through.
Who's appearing for the Union of India? We'll take it up separately in another. We'll keep it up, dealing this matter, just Mishra's matter, and we'll take it up either on Friday or Monday. We'll take it up.
Take only 1 minute, lord. If you lord take, my lord. Only my lordship may seek page number 63 and 64.
Who are you appearing for?
For R.P. Mishra, my lord. This is R.P. Mishra.
We're taking it up. We'll take it up. We are not keeping it in the group. We'll take it up next Monday for Justice R.B. Mishra's matter. And who is appearing for the Union of India?
Learned General was.
This we ask him to be here next Monday. We'll take it up.
There are lot judges. I'll give the numbers of all 3 judges. Sitting judges who are not being denied salary because of this.
Your lordship, one more I.
Not receiving salary?
My lord, I need 30 seconds, my lord.
Vested is not of
My lord, may allow 30 seconds.
Because you were born into a cadre which did not have a assured old pension scheme. You don't have a GPF account. Our software does not provide for giving salaries to a person who does. That is what I am saying. This is
it's for Friday. We'll take it up this Friday.
Very well.
Your lordship.
Take it up because tomorrow, Wednesday, Thursday, we are in a CB. We'll take it up on Friday.
Your lordship's one more application. I mean, not getting pension since 2014. Notice has been issued. That also may be tagged along with this.
No, that's the district. That's all India judges.
That's an all India judges. These High Court judges, we'll take it up on Friday. Let's at least start clearing. Otherwise, if everybody asks for tagging, nothing gets disposed of. At least let's deal with these 2 matters, Mr. Dwivedi's matter and this matter. We'll deal with it this Friday, and then we'll see how best to move forward.
Deeply obliged.
May I circulate a 3-page note?
Yes, please. That will be on that day. You can give it to us.
In that case, my lordship may direct, my lord. That item number 1.3, 1.2, 1.3, and 1.5, my lordship may be taken on Friday, my lord, because all pertains to the judges of the Patna, sitting judges of the Patna High Court and Allahabad High Court.
All right.
1.2, 1.3, and 1.5. I'm grateful.
What is that?
I'm appealing 1.20.
What is that?
That is also retired judges
Panisha, what are those matters?
Those matters are, there is a
from Madhya Pradesh.
fixation of pension for those judges who came from the district judiciary into the High Court. Their pension is now fixed lower than the judges who are elevated from the bar, because the same concern, this old pension, new pension scheme. So at some point of time, because your lordship will decide that old pension, new pension scheme, then all this will fall into place. Essentially, Malas, in all these petitions, the argument is for one rank, one pension. Whether you have served as a High Court judge doesn't matter from what rank you become
a High Court judge, you get the same.
You are entitled to the same pension as any of your colleagues are concerned. That essentially, that's the short point. If that point is decided, let's
that up also immediately.
That is item number 1.15 also, my lord. The same, my lord, the district judiciary.
I will give the list, Malas. I'll give
Just give the list. Permission will give it. But make sure you keep Mr. Dwivedi's matter and RB Mishra's matter first and second. We'll at least take it up, then open the others.
That's 1.15 I'm appearing for the CAG there's a gap, there's a gap between the service before got promoted.
There can't be a difference in pensions of two people born in the same cadre. Can't be that some High Court judges get one pension, other High Court judges get another pension. I'm going to start with 3. No? We just take a.
Kerala, my lord, the state has issued a notification. Whatever you were getting on 31st December 2015, that would be multiplied by 2.81, my lord. This is not correct, my lord, because that payment has to be revised. They have not done it, my lord.
Committee.
This is one thing, my lord.
It's for the allowances.
No, pay.
Pension, my lord.
What? Have you taken it to the committee of judges?
Your order.
My lord.
Because otherwise 32 will become what? Look at, we have spent 2 hours in the morning only doing this on a Monday. That's why we've institutionalized it. Leave something for the committee of judges in the High Courts. They are right there. They should be taking this up.
Given that my lord, they have filed a content petition. My lord has directed the chief secretary to come, my lord, that has been disposed of. But this is the fact, my lord. This is for the Kerala, my lord. And then, my lord, Jammu and Kashmir, my lord. Jammu and Kashmir has 1996, my lord.
Why don't you go to the committee of the High Court and have them look at it? That's why we institutionalize the process. Everything for every individual state, if we start dealing with these individual grievances, it's impossible for us to. Ordinarily, you have to find a 226 petition. Now, just because there's some petition pending, everybody comes with IAs. We have therefore institutionalized the process by constituting committees of judges in the High Court. Surely, there has to be some faith in those committees. We have said we'll meet at least once a month. All right, we'll just rise for 5 minutes. We'll take up skill number 3.
Who has been tagged with item 1. It has something to do with pay revision of the staff of the High Court, which is at par with the Secretary.
So who has to be dealing?
And it is the admitted matter of 2007. Who has to be detagged? It's my respective subject.
Yes.
Can you like?
I may just make a prayer, my lord.